Everybody's still on. All right, the court calls CR 2226, CR 265, State versus Travis Lee Skinner. No, Mr. Skinner will just come to the middle podium there, and court shows that we are set for docket call in each one of these cases.
Yes, sir, that's correct. And a couple of the state previously about this, if we could recess a short period for one more docket call. There's still, as far as discovery goes, I think the state just received the DNA lab results, so I think we have that now, but I have to think the sort of Mr. Skinner. And then there's another recording that we may or may not end up having. I think that's this having an issue about even have the state having access to, but we've been trying to work through that. And so I was going to say we could have a couple more weeks. As far as the DNA lab results, we'll have that part resolved. And then we can, as far as the trial.
State.
The statement agreement, we did just receive those labs back yesterday. We also did notify Biolab, which is a toxicology screen that is still outstanding for analysis. We do not have the result of that back yet. So the contact information for the DNA labs no longer is with the sheriff's office, and that email that it was sent to is no longer searchable. So we have not received lab, just got those yesterday. We called to inquire, but there is still a lab outstanding. So we're not opposed to a reset at this point. Obviously, those might have bearing on whether or not Mr. Skinner is inclined to take a full agreement.
How long do you need, Mr. Sanders?
Well, and I forgot about toxicology report, whenever we discussed that yesterday, so actually maybe as long as 2 weeks, that might be better.
Are you available on April 15th?
Yes, that'd be fine.
All right, Mr. Skinner, the court's going to order you back in person on April 15th at 9 a.m. All right, Mr. Beckham, are you ready? Yes, please. Ms. Davis, if you go to the center podium. This is CR 2328, State versus Amy Irene Davis.
Agreement with the state, the state's file a motion to dismiss, withdraw, a motion to revoke, and
All right, Ms. Davis, if you'll raise your right hand, we'll place you on oath. Ms. Davis, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. So Ms. Davis, the state has submitted a motion to dismiss in CR 2328. The court has granted that. In CR 1892, your probation case, it appears that you are wanting to amend the conditions of your community supervision. And in that amendment would include an extension of your community supervision period for 3 months. That would extend you until July 9th of 2023. With that extension, you would also incur additional costs. You understand that, is that correct? And you're asking the court to approve that today? And why are you asking the court to extend your community supervision?
Your Honor, it's so that she will serve the full term of the 5-year community supervision.
Okay. All right. The court's going to approve the amendment to the conditions of community supervision, and the court has granted and signed the order of dismissal in CR 2328. Do you need to see Ms. Davis before she goes? All right, Ms. Davis, you're free to go.
Your Honor, I'm sorry, the state of Oklahoma filed a motion to withdraw, a motion to revoke.
All right, court will grant the state's motion to withdraw. All right, you're free to go.
Thank you, Your Honor.
Yes, thank you, Mr. Markham. Mr. Calabria,
Yes, Your Honor.
are you and your client ready?
No, sir, I need to fix that.
Okay, that's fine. Do we know if Mr. Atkins and Mr. Hunter are going to be here? Because I mean, they were both ordered to be here. I know he's going to withdraw, but
I believe filed a motion for continuance that was rejected by the clerk's office, so it's not before the court, but we have no objection to your reset since that motion has been withdrawn. I believe he's just going to request to put it back on the docket for Dr. Shaw. That's my understanding.
so there is a motion for continuance somewhere.
Somewhere.
Do we know why it was rejected? It's okay if you don't know, just if you did know.
Why it was rejected. Mr. Atkins, in spite of the PR bond, is still in jail.
Okay. I just want to make sure we get him reset so he doesn't fall through the cracks. Tiara Randall. Let me step across and see if Karen has the probation extension. Just one moment. Let me get your paperwork and we'll get you processed. Yes. Do you have that? Oh, okay. This afternoon. All right, Ms. Randall, if you'll raise your right hand. Ms. Randall, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. Mr. Randall, are you currently on community supervision? It appears to me that there's a request for you to extend the period of your community supervision by 1 year, which would extend your reporting period until March 30th of 2022. Is that correct? Why are you asking the court to extend your community supervision period?
Since I got out, I paid off all my probation fines, work loss, all that stuff, but my county and Tarrant County, all their community service places are closed. And I asked Rachel, my probation officer down here, if I could donate or pay for some hours, anything possible that I could do, so I looking for work. She told me to ask if there was any way that, because my county and Tarrant, they accept those. But she told me to ask you if it would be possible if I could donate for the rest of the hours.
She told you to ask me?
Ask if that would be possible, yes, because my county up there in Tarrant County, they allowed that. And she said that.
And if you were able to do that, would you need an extension of your community supervision?
Well, I thought it was extended for 6 months, so.
Tell you what, why don't you come back here and meet with Ms. Burns, and then I'll recall your case in a little bit.
Mr. Hankins was hanged for a period of time while he was required to do standardized sobriety testing during the course of that testing. Another officer conducted a search of his vehicle, and we are not contesting the initial stop or the alleged speeding. We are contesting the validity of the search and the scope of the search. And it is our position it was done without a warrant, without probable cause, and that the state bears the burden to prove the reasonableness of the search. And Your Honor, we would ask him about the rule. I don't know if both witnesses are present, but we would ask him about the rule at this time.
State.
Your Honor, the state is ready to proceed. We'll have the second, we expect to call, step out while we call our first.
And who are the troopers?
It's Trooper Justin Road, Trooper Drew Bagley.
All right, Trooper Rhodes and Trooper Fagley, if you'll step up, please. Who do you anticipate calling first?
Trooper Road.
If you'll go ahead and y'all step up to the podium there. All right, go ahead and raise your right hands. I'm going to go ahead and swear you in at this time. Do each of you gentlemen swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Trooper Fagley?
Yes, sir.
Trooper Rhodes? All right, you may put your hands down. All right, gentlemen, the rule has been invoked for the purposes of this hearing. If you are not in the courtroom testifying, you're to remain outside the courtroom. You're not to have any discussions with anyone regarding the substance of this case. You're to remain outside the hearing of anyone discussing this case. You are allowed to discuss this case with the attorneys or their staff. All right, but no discussions with each other or anyone else regarding this case. Do you understand? All right, and so Trooper Fagley is going to be first, is that correct? Trooper Rose. So Trooper Fagley, if you'll go ahead and step out at this time. You know, we're going to want opening arguments.
Your Honor, I believe Mr. had basically made his, so I would just reserve, I'll just go straight to our witnesses.
All right, Trooper Rhodes, if you'll come on up. All right, go ahead and have a seat and make yourself comfortable. The bailiff will adjust the microphone for you. All right, Trooper Rose, during your testimony today, make sure you speak up loudly and clearly. The mask is at your discretion. You're not required to wear that in the court during your testimony. Make sure that you allow counsel to have time to fully ask their question before you give an answer so that we're not talking over one another. And counsel, you'll extend that same courtesy to Trooper Rose. Go ahead, Ms. Heisel.
Thank you, Your Honor. Trooper Road, would you say and spell your name for the record, please?
Justin Rhodes, JUSTIN RHODES.
And how are you currently employed?
I'm employed with the Texas Department of Public Safety as the Texas State Trooper.
Does that mean you're a certified police officer in the state of Texas? How long have you been a certified police officer?
I've been with DPS for 6 months, 6 years and 3 months.
And what are some of your job descriptions here at the DPS office in Union?
So we work traffic control. We ensure that the laws of the state, whether it's transportation code, family code, whatever laws, we ensure that those are.
Do you also does that encompass DWI stops, drug interdictions, and things of that nature?
Yes, ma'am.
And on October the 5th, 2019, did you have occasion to stop a vehicle driven by Quincy Hankins?
Yes, ma'am.
Do you see Mr. Hankins here in the courtroom?
I do.
Could you identify him by what he's wearing, where he's sitting?
Yes, ma'am. At the defense table, wearing a black suit. Red.
And that is the same gentleman that you stopped on the night of October 5th.
Yes,
Your Honor, have the record reflect the court identification of the defendant.
Court will note that this witness has identified the defendant for the purposes of this hearing as Quincy Lamar Hankins.
And Trooper Rhodes, do you remember the reason for the traffic stop on Mr. Hankins?
Yes, ma'am, it's for the offensive speed.
And do you remember, what he was going and what the posted speed limit was?
Yes, ma'am, he was traveling 72 miles per hour and they posted 45 miles per hour.
And did you, notice anything unusual about this traffic stop, when you initially stopped Mr. Hankins' vehicle?
Yes, ma'am.
And what was that?
Prior to me exiting the vehicle, I could smell a heavy, strong odor of some sort of fragrance
Before exiting your vehicle?
before exiting my vehicle.
And is that unusual for you on traffic stops?
Yes, ma'am.
Did you approach Mr. Hankins' vehicle?
Yes, ma'am.
And did you observe anything, unusual while approaching his vehicle?
I did observe the odor became stronger as I approached his vehicle, and I observed that his sunroof was open.
Did you, make contact with Mr. Hankins? Did you discuss the overwhelming scent, I believe that was your phrasing of that odor with Mr. Hankins?
Yes.
What, in your training and experience, what does that denote to you as an officer when you're in that kind of situation?
With my training and experience, typically it's used to cover up an odor of possibly legal narcotic, such as marijuana.
And do you see that fairly often in your, in the course of your job? Kind of describe for us how the traffic stop went there.
I identified Mr. Hankins. He initially gave me his military identification card. I advised him I needed his driver's license. He did not have his driver's license, so I therefore had to collect information so I could get him identified. While I was speaking with him, I believed I could smell the faint odor of alcohol, and then therefore I got him out to talk to him further.
And when you discussed the fragrance that you were smelling with Mr. Hankins, did he have any explanation for that odor?
I asked him if he had sprayed some sort of fragrance or cologne in his vehicle. He told me he did not. He actually told me he didn't have anything to spray.
Okay, and was that consistent? Did you believe that was consistent with what you were observing? So I believe you said you asked Mr. Hankins to step out of the vehicle, is that correct? Did you ultimately determine that you could smell alcohol on his breath? And did you, at that point, ask him to consent to standardized field sobriety testing?
And Trooper Rhodes, you're going to have to speak up.
And Trooper Rhodes, was there anybody on scene with you during this traffic stop for your department?
Yes, ma'am.
Who was that?
Trooper Andrew Fagley.
So based on what you were being told by Mr. Hankins, and what you believe to be inconsistencies, did you at that point believe you had probable cause to search that vehicle?
I believed I had a reasonable suspicion.
Okay. And did Mr. Hankins disclose anything else to you that led to probable cause for search of the vehicle?
Yes.
And what was that?
He told me that he had an open bottle of whiskey in his backseat.
So while you did standardized field sobriety testing, did you ask Trooper Fagley to conduct a search of his vehicle?
I did.
And again, that was based on the odor in addition to his admission of having an open container in the vehicle. Is that correct?
Yes.
approach?
You may.
I know, I'm sorry. Thank you. Trooper Rhodes, I'm showing you what I'm marking to be State Exhibit 1. Do you recognize this? What is it?
It is a copy of my video.
Okay, and have you personally reviewed this video?
I have,
And do the contents of this video accurately portray the events of that evening?
yes,
Has it been altered in any way? Do you believe that that would be helpful for the court in understanding your perspective from that?
yes.
Your Honor, we offer State 1. This is Trooper Rhodes' body.
Your Honor, I have no objection for the purpose of this hearing.
All right, State's Exhibit 1, Trooper Rhodes body cam is admitted in evidence for the purpose of the defendant's motion to suppress.
And Your Honor, may I publish via television?
Yes, you're going to need to either hard connect, or I'm going to give you the password to connect.
I can also publish it via Zoom, Your Honor, whatever the court prefers.
Let's publish it via Zoom. Let's try that. If that doesn't work, then we'll try plan B. So Ms. Hazel, you're going to log into Zoom?
I am, Your
Right.
Honor. Do we have the Zoom ID available?
Yes. It is.
Not, I'm not sure what the remedy would be, Your Honor.
Do you know when that's going to occur?
Very shortly, Your Honor.
I'll just continue to be under mute at this time and then we'll
You were in the army. Forces, in nighttime. Medical examiner. So you were in the medical forces, and you seem like a decent guy. How do you not pay your traffic tickets? How do you get your traffic? Well, I understand you get traffic tickets, you do 72 and those. Back before surgery. I had talked to someone today. It sounds so bad. I did not want to fight. Okay, some of them, yes, they were like, I got it. And then the news will come out, that's still there. So surgery to speak over. I need to pay them, but I haven't. And that sounds so bad. And then situation I know, I'm probably that was. All right, I'm secretary. All right, and I'm Sean Haynes, from. All right, give me just a second, I'll be right back, so you okay? Did you, yeah, yes. I don't have one, so. So I won't try to get rid of it. Right now, that's right. Thanks, yeah, it's right. It's okay. Probably not. Yes. Yeah, so he won't be able to do it. Yeah. Okay. He got. Okay, let me back it up. I'll show 10-6. Yes. Here we go. I'm just gonna, I'll flip around, so just try to use that. Okay. Yeah, Quincy. was open. He said he was right there. Yeah, I wanted to check that. And honestly, I can, in right here, you can see. So, I would check it, for tanks. Hey, what's it,
Your Honor, the state is going to stop publication at this time, but just for the court's record, there's almost an hour remaining. The state's exhibit one.
Okay.
So Trooper Rhodes, you said that you have approached the vehicle and smelled the odor, some sort of spray fragrance, that at that point you had reasonable suspicion that there may be some kind of narcotics like marijuana in the car. Is that correct?
Yes.
And after you got Mr. Hankins out of the vehicle and you began speaking with him, did you have any other reasons in your conversation with him that aided in drawing that up to the level of probable cause to search?
Yes.
And what were those?
He openly admitted to me that there was open container in his backseat, which was behind the last upright seat.
Okay. And in regards to the odor that you were smelling, when Mr. Hankins mentioned that he smoked Black and Mild cigarettes or cigars, does that indicate anything to you? Is that commonly used to smoke marijuana?
Yes, in my training experience.
And the fact that Mr. Hankins brought up marijuana without you questioning him for marijuana, in your training experience, what does that typically denote to you?
Typically, that's what substance, in my training experience, previous arrests, that's the substance that I find to be.
Do you find that typically people's minds go to what they're most worried about?
Yes.
So based on those statements that you made, at that point, you believed you had probable cause to search for marijuana as well. Is that correct?
Yes.
And then you had Trooper Fadley assist you in that search. Is that correct?
Yes.
You're not pass the witness.
Mr. Head. And can we have the lights back on? Bailiff, will you assist?
Trooper Rhodes, you've been trained in your training as a trooper to write reports, is that correct?
Yes, sir.
And in fact, in this case, you did write.
Yes, sir.
And it's critical in writing a report that you write a complete and accurate report.
Yes, sir.
Would you say that your report in this case is complete and accurate?
To the best of my knowledge, yes, sir.
Have you had an opportunity to review it prior to testifying today?
Yes, sir.
Is there anything that you would like to correct at this point in time before we proceed on with cross-examination?
To my knowledge, the only thing that I read would be the in-car radar. Lead I used for rear facing in-car radar.
So other than the fact that you listed the incorrect radar, nothing else that you're aware of? Would you agree with me that in your report, you indicate that the search that was conducted was strictly for open containers? You agree with me? That's what your report says.
I'd have to look at my report.
Do you have a copy with you?
Yes, sir.
Okay, can you take a look at that?
Yes, sir.
In fact, the report specifically says that the search that was conducted was for open containers.
For the open container.
And in the open container was the one that Mr. Hankins was honest with you about where it was, what it was, and was truthful with you about that. You would agree with me that your report says absolutely nothing about having probable cause to search for marijuana?
If I'm ever.
Yes, sir, please do.
Yes, sir, that's correct.
And this report was written after the conclusion of this incident, correct?
Yes, sir.
Nothing that prevented you from putting everything in the report related to the stop and the search.
That's correct.
You had adequate time, no one was telling you, you gotta get this done by a certain time. It's important to be truthful, honest, and complete in the report, correct?
That's correct.
At what point in time later than after the report was concluded, did you come up with the idea that you had probable cause to search for marijuana?
Restate that question.
Okay. You testified here today that you believe you had probable cause to search for marijuana.
I had
Is
a,
that true? That you testified to that?
the way I saw it, sir, I had a reasonable suspicion to search for marijuana. I had probable cause to search for the.
Okay, so you're testifying today that you did not have probable cause to search for marijuana.
No, sir, I did not. At the time, I advised Trooper Fagan to search.
And is it your understanding of the law that reasonable suspicion allows you to search a vehicle?
No, sir, that is not.
So you would agree with me then that a search for marijuana would have been improper?
Yes, sir.
And in fact, you've indicated that the basis for the stop was speeding, correct?
Yes, sir.
And you stopped, and then a separate officer, Officer Fagley, did I pronounce his name right? I said,
Yes, sir. Trooper Fagan.
and he was in a separate marked unit, correct?
Yes, sir.
And he also stopped.
Yes, sir.
It is a normal DPS policy to have two officers to conduct a traffic stop for a speeding violation.
It's not uncommon.
And I would assume that you're capable and trained and able to do a speeding stop on your own without another officer.
Yes, sir.
Did you request him to stay for that stop?
No, sir, I didn't question him, so you just said.
And is it, and certainly you didn't request him to do an illegal search of the vehicle for marijuana, did you?
No, sir.
Do you recall you speaking to him about the search? And you're telling him, check for open containers and then you just kind of trail off and there's nothing else said. Do you recall hearing that?
In the video just now?
Yes, sir.
Yes, sir.
What else were you implying by the word "and" for him to search for?
To see if he found anything else, any other open containers, maybe. I had a reasonable suspicion to believe that there may have been marijuana in the vehicle, but the probable cause search was for the open container.
And that open container was in plain view in the back seat, as Mr. Hankins had indicated. Is that correct?
I believe that's what you're saying.
And in this case specifically, you did or had an in-car video, is that true?
Yes, sir.
And that would be standard for DPS to have an in-car video.
Yes, sir.
Likewise, you had a body cam video, and that's the one we've been watching, is that correct?
Yes, sir.
And that would be standard as well.
Yes, sir.
And so to your knowledge, we should have for Trooper Fagley a in-car as well as a body cam as well.
Objection, Your Honor, false speculation. I don't believe you have any personal knowledge of what equipment Trooper Fagley would have looked at.
Your Honor, I'm just asking in his training and experience, it would be normal. Maybe I can rephrase, Your Honor.
Please do. Also sustain the objection.
In your training and experience with DPS, would it be normal in that particular date for each trooper to be equipped with an in-car video as well as a body camera. That's correct. Do you have any personal knowledge of any reason why Trooper Fagin would not have a body camera?
No, sir.
He didn't indicate to you it wasn't working, anything of that nature that you recall?
No, sir.
And you would agree with me that Mr. Hankins was compliant and cooperative?
Yes, sir. I agree with that.
He followed your instructions to get out of the vehicle. He volunteered information about his license, all of that type of thing.
Yes, sir.
And certainly in your experience as a trooper, you're also trained in specifically DWI intervention. Is that true?
Yes, sir.
So you're familiar with the manuals related to clues of intoxication.
Yes, sir.
And would you agree with me that other than an admission of having 2 drinks, you do not put any clues of intoxication in your report?
Your Honor, I'm gonna object to this under relevance for the scope of the suppression hearing regarding the search. I'm not sure if that any part of the DWI investigation as well.
Your Honor, it's our position, the only potential valid basis for the continued detention was a DWI investigation. And if that DWI investigation and continued detention was not valid or lawful, then anything acquired by the officers pursuant to that likewise was unlawfully obtained. So I believe whether or not that was a valid continued detention for a DWI investigation is relevant and material.
Court will overrule the objection.
Trooper, would you agree with me that other than the admission of having drank 2 alcoholic beverages, there is nothing in your report indicating any clues of intoxication?
At that time, I spoke with him when he admitted to drinking at that time, other than me smelling the odor of alcohol on his breath.
Well, and specifically, you know that there's any sort of slurred speech, is that true?
That's true. I didn't observe slur speech.
No red, watery, bloodshot eyes,
Not that that's not that I remember. Sir.
no sway, stagger, anything of that nature.
Not that I can remember.
Produced identification, he didn't fumble for his identification or anything related to his identification or insurance. And you noted things like that in prior DWI stops.
Yes, sir. I have.
Okay. None of that was present in this instance.
No, sir.
Didn't have difficulties operating his motor vehicle as far as use turn signals, parked correctly, exited correctly, all of those things that you might look for and note if there were any clues of potential intoxication. None of those things were present. Is that true?
Not that I remember.
So the only thing that you were basing a continued detention on was a faint odor of alcohol, which you're now saying you can smell over this fragrance. Is that correct?
Once I was talking to him and he was out of the vehicle, I was able to smell the odor of alcohol as well as the heavy odor of the fragrance.
And then his admission of having consumed alcoholic beverages.
Yes, sir.
And is it your position that that alone amounts to probable cause for a continued detention for DWI?
Can you rephrase the question?
Is it your position that that alone allowed for the continued detention for DWI?
It was my position that I wanted to ensure he was sober, safe to continue driving.
Well, you would agree with me, he was not free to leave at that point. So you were detained
Yes, sir.
for an investigation.
Yes, sir.
Do you believe that you had probable cause for that detention?
At the time, I believe I did.
In hindsight, would you agree with me that the smell of alcohol alone and an admission of some amount does not amount to probable cause for?
I'm unsure of any case law that would say against that.
And you would agree with me that an open container violation cannot result in an arrest. Is that fair?
I'd agree with that.
It's not an arrestable offense under Texas law.
Yes.
I'm passing it.
Besides one.
Is it true that you and Trooper Bagley discussed the clues regarding possible marijuana in the car when you were talking to him about preparing for the search of the vehicle? In fact, when you told him that you wished him to assist you by searching the vehicle, you said there's no container in the car, and plus, I believe you said all the other stuff. Is that right? So when you are communicating with Trooper Bagley for the search, you assert both the alcohol and the odor masking and suspected marijuana.
Sustained.
I'll rephrase your honor. Trooper Rhodes, do you, was it your intention for Trooper Bagley to search for both of those things?
At the time, I believe we had probable cause to search for the alcohol. I only had a reasonable suspicion to believe that there may have been marijuana in there. My intention was for him to search for the
Your honor, pass witness.
Mr. Head, any additional questions for Trooper Rhodes?
No, well, I could follow up. In searching for an open container, would you agree with me that you wouldn't find an open container above a sun visor?
unless he, when, after I approached the vehicle, stuck one on top of the vehicle. He had a tailor, stuck it up, opened the sunrise, and stuck it on the top of the vehicle.
Okay, well, I guess my question is, when you're searching for an open container, it would be fair to say that it would have to be in an area large enough to contain the open container. Is that reasonable?
Yes, sir.
Pass it.
Any additional questions from the state?
No, your honor.
Any objection to Trooper Rhodes being finally excused?
No, sir, Your Honor.
Trooper Rhodes, free to step down, free to go. Thank you, sir. State, do you have any additional witnesses?
Your honor, state would call Trooper Andrew Bagley.
Thank you, Mr. Woodward. Trooper Fagley, if you'll approach, stand. Trooper Fagley, you were previously placed under oath. Recall that, sir? And since your departure from the courtroom, you've observed the instructions of the court and not spoken with anyone about this case. Is that correct?
Yes, sir.
Please have a seat. Please get comfortable and speak directly into the microphone. Make sure you speak up loudly and clearly so my court reporter can hear you and take down a transcript. The attorneys are going to ask questions. Allow them to fully ask their questions before you give an answer, even though you anticipate what the questions may be, so that my court reporter can take down who is saying what. And the attorneys are going to give you time to fully complete your answer before they ask their next question. Go ahead, Ms. Heisel.
Thank you, Your Honor. Trooper Fabry, could you say and spell your name for the court record?
Andrew, Andrew, Fagley, Fag as in George, Li.
And Trooper Fabry, how are you currently employed?
State trooper with the Texas Department of Police.
And how long have you been in that position?
A little over 9 years.
Are you certified police officer in the state of Texas?
Yes, ma'am.
And just briefly, can you go over the training experience that is required for you to become a licensed police officer?
The basic peace officer training academy, which UPS puts on there also, which lasts approximately 6 months, including the state licensing test to be certified police officer.
And what are some of your job duties here in Canton TDS office?
Routine patrol, traffic stops, crash investigations, and then different types of maybe criminal investigations if necessary.
On October the 5th of 2019, did you have cause to assist Trooper Justin Rhodes on a traffic stop on a Quincy Hankins?
Yes, sir.
And were you and Trooper Rhodes patrolling together when Trooper Rhodes pulled Mr. Hankins over for speeding?
Yes, sir.
And you observed Trooper Rhodes, did you observe Trooper Rhodes have communication with Mr. Hankins?
Yes, sir.
After that point, did Trooper Rhodes ask you to perform a probable cause search of his vehicle?
Yes, sir.
And did he assess to you that the reason for the probable cause search was that?
Objection leading.
Overruled.
Thank you, Your Honor. Did he assert to you that the reason was that Mr. Hankins had both admitted to an open container in the vehicle, and also did he mention to you the masking of odor as a probable cause search for marijuana?
Yes, sir.
So at the time that you began your search, you believe there was probable cause to search for both alcohol and marijuana, is that correct?
Yes, sir.
And did you search Mr. Hankins' vehicle?
Yes, sir.
What substances did you find in the vehicle, and where did you find them that were a violation of the law?
A Crown Royal bottle that had a broken seal and partially empty was in the back passenger side floorboard, rear seat floorboard. The front cup holder contained a foam cup with condensation on the side, which would be a cold liquid, which had the same feature that would be matching with Crown Royal, as well as a beer cellophane type of cigar wrapper in the center console with a small piece of green marijuana resin, or piece of green marijuana, and two full quality choppy tablets in this same wrapper.
Okay, and did you also observe marijuana residue around the console cup holder area?
Yes, ma'am.
And in your training experience, what would you believe those 2 tablet pills to be?
Ecstasy.
And the shape and appearance of those pills were those consistent with what you routinely see as ecstasy in the field?
Yes, ma'am.
Trooper Fagley, the peach Crown Royal that was, did you say it was located in the back seat?
The bottle.
The bottle was?
Yes, ma'am.
Okay. And was that accessible from the front driver's seat?
Yes, sir.
And while you were looking for that, did you notice anything else in plain view, that gave you further cause to search the vehicle?
Are you referring to the rear seat area or the,
If,
I mean,
while you were looking for that open container bottle, did you see anything else in plain view in the vehicle, that caught your attention?
right offhand, other than the marijuana residue that I notated and we talked about on the center console, nothing that comes to mind of it.
And that marijuana residue, was that in plain view to you while you were searching?
Yes, sir.
And did that give you probable cause to continue a search for further, marijuana in the vehicle?
Yes, sir.
And then is that when you open the center console to reveal the rest of the, narcotics that you located?
Yes, sir.
And Trooper Bagley, did you have any, prior knowledge about, the defendant's admissions about his, cigars?
I remember him explaining to Trooper Rhodes that he smoked cigars. And reference to not having marijuana or not. So,
In your training and experience, is it, unusual for someone to bring up, drugs to a police officer before the police officer himself has mentioned them?
yes, sir.
What does that denote to you?
That they're thinking about it before I am.
And Trooper Bagley, the marijuana and the, two pills that you believe to be ecstasy, where were those ultimately located? What kind of package?
The same type of cigar package that he was describing.
Your Honor, pass the witness.
Mr. Head.
Trooper Bagley, did you write a separate report or just a supplemental paragraph on Trooper Rhodes' report?
Supplemental. The tax.
Other than that one paragraph titled supplemental report, there's no additional report that you prepared.
That's correct.
And you've been trained in report writing. And any additions, deletions, corrections, anything you think of that you need to make to that before you proceed with your testimony?
No, sir.
And it's your testimony that the search that you were requested to conduct was a probable cause search for marijuana and open containers.
Specifying marijuana only, does that mean?
No, I believe, I understood your testimony to be that you believe you had probable cause to search for marijuana at the time you initiated the search.
Yes, sir.
And that had been expressed to you by Trooper Rhodes to search for marijuana as well as open containers.
Never specifically stated marijuana, no, sir.
He just said do a full search of the vehicle.
A probable cause search.
So was your search limited then to open containers, or was it for marijuana, or what exactly were you searching for?
Contraband inside the vehicle.
So you felt like you had probable cause to search for contraband?
That is what open containers are, yes, sir. Yeah, as well as marijuana.
Well, and I just want to be clear, when you opened the door and started searching, you were searching for open containers and or marijuana and or contraband.
Not and or, those can all be considered contraband, but when I open the door and then when I make additional observations of marijuana residue, that's what specifically tells me marijuana.
Did you take any photographs of this alleged marijuana resident?
No, sir.
Did you do any sort of testing to see if it was resident?
No.
All right. Now, your vehicle was equipped with an in-car video system, is that correct?
Yes, sir.
Likewise, you're equipped with a body camera.
Yes, sir.
And was your body camera working on that occasion?
Yes, sir.
And that's been submitted to the state.
Yes, sir.
Your Honor, at this point in time, we don't have the body camera in discovery. I would have to ask that we have a recess. I don't know if it's just oversight or if it somehow didn't get from the trooper to the state, I don't know. But it was not provided in our discovery.
Your Honor, we would agree to a recess, and I believe I have an answer from Mr. Kevin.
Okay, all right, the court will take a recess, and this cause number, Trooper Fackley, you're still under oath and you're still under the rules. So I'm gonna have you step down at this time and we'll recall the case shortly.
Yes, sir.
Mr. Calabria, are you ready?
Yes,
Do you have your client approach the center podium? Ms. Heisel, if I can have you and Mr. Head, just,
Yes, Your Honor.
it's okay. No, you don't have to move your stuff. You don't have to move your stuff if y'all just take your conversation elsewhere. All right, Mr. Calabria, are we entering a plea today or do we have some other topic? All right, are you Jerry Edward Anthony Jr.? All right, and Mr. Anthony, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. All right, Mr. Anthony, have you taken enough time today to review this paperwork with your attorney, Mr. Calabria? Do you feel like you understand everything that you've read and signed? Your name as it appears in this document, is it your true and correct signature? And did you only sign this document once you fully understood what you were reading and signing? And are you pleased with Mr. Calabria's representation of you? Do you feel like you've had enough time to discuss your case with him, have all of your legal questions answered? Mr. Calabria, do you believe Mr. Anthony to be competent today?
I do, Your Honor.
You've explained to him his legal and constitutional rights.
I have, Your Honor.
Does your client waive the formal reading of the state's motion to adjudicate in this matter?
Permission of the court, yes, sir.
And is it his intention to plead true to all 6 counts as contained in the motion?
Yes, sir.
It's my understanding by looking at the documents that upon pleading true that or that the state would be recommending that Mr. Anthony's community supervision be revoked, that his guilt be adjudicated, and that he be sentenced to 5 years confinement in the Texas Department of Criminal Justice in order to pay his financial obligations from the plea, and that he receive 18 days credit for time spent in jail towards his sentence in this case. Is that your understanding, Mr. Calabria?
That's our understanding. Your Honor.
Yours as well, Mr. Anthony? All right, Mr. Anthony, at this time, I'm going to ask you then, how do you plead to counts 1, 2, 3, 4, 5, and 6 as contained in the state's motion to adjudicate filed November 18th of 2020? You would need to either tell me those are true or not true. Okay, and so Mr. Anthony, are you pleading true to each one of those counts because each one of those counts is true? And you're not pleading true to get a better deal or anything like that. Is that correct? You're not just pleading true just to get a certain type of plea agreement. Is that right? You're pleading true to these because these allegations about you are true. All right, the court will accept Mr. Anthony's pleas of true to each of the counts alleged in the state's motion. Mr. Clavery, any objection to the admission of State's Exhibit A, the defendant's waiver of rights and plea of truth?
Okay.
All right, State's Exhibit A is admitted into evidence. The court takes judicial notice of Mr. Anthony's judicial confession. Is there anything from the state? All right. Anything further from the defense, Mr. Clavery?
No, Your Honor, we read it.
All right, Mr. Anthony, based on the court's review of the evidence, I find that you have violated the terms and conditions of your community supervision. The court finds counts 1, 2, 3, 4, 5, and 6 to be true. The court hereby follows the recommendation in this case. Court adjudicates your guilt, convicts you this date of aggravated assault causes serious bodily injury. Court revokes your community supervision, assesses your punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. The court orders you to pay the balance of your financial obligations previously ordered. The court awards you 18 days confinement. 18 days towards your confinement for the time that you have spent in jail on this cause. Anthony, when you do get out of TDC, if you have not already made arrangements to pay the things that you owe, then you're ordered to report to the courthouse and meet with the court's compliance officer so we can set up a payment plan to have you discharge the things that you owe. Your failure to do that will result in a warrant being issued for your arrest, and you're going to find yourself back in the same situation you're in today. You understand? All right, I'm going to have you come forward. Are you going to assist? I'm going to have you come forward and be fingerprinted, after which time you'll be taken into custody. Yes, thank you, Mr. Claiborne. All right, so it's my understanding that Mr. Thomason is taking a plea.
Yes, Judge.
Okay. Mr. Hunt, I don't believe that we have Mr. Atkins here. Is he the only one you had on the docket today?
He is, Your Honor, and we don't need him here today. I tried to file continuance over a refile. Did you get a notice? I don't know if I did, it may have gone in my spam, but it didn't go through. He was injured in an incident at the jail and received a brain injury. Back in the jail now. I'm working on that issue. But I fully intend to withdraw that motion to suppress and review the evidence. I don't know if there's anything to suppress in that case. Now, in the new case, I don't know. I haven't received all the discovery or what I have. I don't know. There's a I can't remember if it's a body cam. I think it's, and
In the new case?
yes, and I've spoken to Ms. Heisel, and she's told me that she doesn't think that the body can't work or something. Then we're going to look into it. I haven't heard of it.
Don't now believe that Mr. Hunt has all the videos available to the state, however, he does not have the 911 call. We requested that, and Sergeant Hanley is in the process. He has a copy, he's bringing it to our office, but we don't have that yet to pay for Mr. Hunt. I expect that in the next couple of days.
I don't think those cases. Necessarily.
I was just looking that up myself. I see that the indictment was returned earlier this month, but there's been no setting on that. So, all right. So the only thing that before the court today anyway is the motion to suppress. And if you're going to withdraw that, then if you'll just file your withdrawal so we can put it in the record because we're not on the record right now. Then let's go ahead and we'll set this motion to revoke on April 29th. And if we'll just go ahead and fill out a notice of setting, then I'll let you get that to Mr. Atkins. That's what my docket says. Could be an error in my docket, but
I believe so, Your Honor. I think they're both.
Yeah, I believe it was, yeah. I believe that's correct.
yeah, for whatever reason, it says MTR on mine, but then we'll go ahead and we'll set that for docket call to, let me ask Ms. Taberham if we have an anticipated date on the other case. Okay, it's probably further out. So like. Me? Probably. Okay, so I'll just shoot for like May 11th. Okay. that makes- Mr. Hunt, are you available on May 11th? It's a Tuesday, second Tuesday in May.
I am, Your Honor.
We'll set it for docket call on that date and I'll let you inform Mr. Atkins of that and we'll see if the new case is, I don't believe that the indictments have been, they've been received by the clerk, but they have not been communicated to my staff for purposes of setting. So we do not have that set. We anticipate that when we do receive it, we'd probably look at May 11th. So we'll try to put those together.
Okay, you said 9 a.m.
We'll set it for, well, he's in custody, correct? So we'll set that at 1:30. And if he's on bail, then it'll be at 9 a.m.
Thank you, Your Honor.
You're welcome. And if you'll just fill one of those out and I'll let you take the yellow copy. If you'll just sign, just indicate on there that Mr. Atkinson is incarcerated. All right, any update on Mr. Higgins? Do we need additional time for Mr. Head to be able to review the video?
Your Honor, it was
Yes, off the record. All right, the court cause numbers CR 2313 and 314, State versus James Matthew Thompson. You are James Matthew Thompson, correct? Mr. Thomason, if you'll raise your right hand and place you on oath. Sir, do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Give me just a moment. I'm gonna look through your paperwork. Offense report, the only thing I have in the stipulation is the indictment. If you do not have it, I do have a PSI that if I'm not going to use this, then you're welcome to take from the office report that's in here. But it may be printed front and back though.
Judge, I have provided this to the trooper. That is the copy that goes.
And Mr. Gimbel, I want you to, have you reviewed the offense reports in this case? So what Mr. Woodwalk has handed to me is the DPS report from Trooper Powell. Why don't you come review this? And this is see if you have any objection to that being included in the stipulation.
No objection.
All right. Of course, I include that in the stipulation of evidence. All right, Mr. Thomason, are you a United States citizen?
Yes.
Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? What have you been diagnosed with? Are you currently undergoing any type of treatment or on any kind of medication to assist with that disorder?
Yes.
What are you currently on, medication wise? Do you feel like those medications are assisting you today and giving you rational thought so that you can understand the proceedings against you? Have you feel like you've had enough time to discuss your case with Mr. Gimbel and have all of your legal questions answered? You feel like there's anything that you do not understand about the documents that you've read and signed today regarding your plea agreement in this case? Are you pleased with Mr. Gimbel's representation of you? Mr. Gimbel, do you believe Mr. Thomason to be competent today? Based on his statement that he is diagnosed with schizophrenia and is currently undergoing medical treatment for that, do you have any concerns about his competency up until this point?
When I first met Mr. Thompson several months ago, I admit I would have had concerns regarding his competency, but since under supervision at Van Zandt County Jail, he's been provided, like you said, the Seroquel and the trazodone, and I've noticed a remarkable change and improvement in his demeanor, and seems much more rational and reasonable. And every time I visited him in the last few months.
Okay, and you've explained to Mr. Thomason his legal and constitutional rights in this case?
Yes, sir.
It's my understanding that Mr. Thomason has two charges, one of them being evading with a vehicle, a third-degree felony, and also fraudulent use or possession of identifying information from an elderly. It appears that the plea agreement is that Mr. Thomason's going to plead guilty to the evading arrest or detention with a vehicle in exchange for the state's recommendation of 10 years confinement, TDC, $1,500 fine, with the state taking into consideration CR 2314, the fraudulent use or possession of identifying information, and also an unauthorized use of vehicle. Is that correct, Mr. Woodwhite?
Yes, just that's correct.
Mr. Gimbel, on behalf of yourself and your client, is that your understanding?
That's correct. That is our understanding.
If I could, there's also an unindicted, unauthorized use of motor vehicle that the state is rejecting at this time as well.
Okay.
As I don't believe it's reflecting the paperwork because it's not a indicted case and we not intend to close that case in our office. We will not.
Okay. All right, Mr. Thomason. Having been charged with a third-degree felony offense of evading arrest or detention with a vehicle, you need to understand the range of punishment in that case is confinement in the Texas Department of Criminal Justice for a period of not less than 2 years or more than 10 years, and a fine not to exceed $10,000. If the court were to assess punishment by way of plea agreement or by trial or a jury assessed punishment, it would have to be somewhere within 2 to 10. You understand that? And it appears by plea agreement today that the recommendation of 10 years would fall within that range of punishment. Do you understand that?
The state has also filed a this time that would enhance the state. But we've abandoned that as charged. Just with
Thank you, sir. All right, Mr. Thomason, then to the third-degree felony offense of evading arrest or detention with a vehicle, how do you plead? Mr. Thomason, are you pleading guilty to that charge because you are guilty of that charge and for no other reason? Has anyone threatened you, forced you, or pressured you to plead guilty to that charge? All right, the court accepts Mr. Thomason's plea of guilt. Mr. Gimbel, any objection to the admission of State's Exhibit 1, the stipulation of evidence?
No, okay.
Stipulation of evidence is admitted. And the court takes judicial notice of Mr. Thomason's judicial confession. Anything further from the state?
Judge, only that the state would know that we have received a victim impact report case that we are taking into consideration. We would note to the court that it's filled out entirely with not applicable /to everything. We did not feel it was necessary to bring that to the court because it's not the case that's being pled. We just wanted the court to be aware we did receive a visit on the other case, but it was not filled out in any meaningful way, so we're not going to present it to the court. Beyond that, state has nothing further. to propose.
Thank you, Mr. Woodwhack. Mr. Gimbel, anything further from the defendant? All right, the court had previously reviewed the pre-sentence investigation report that was prepared by the Community Supervision Department in anticipation of the open plea that was previously indicated to the court. So the court reviewed that in its entirety, so I'm familiar with the facts of the case. So based on the evidence presented to this court, the court will follow the recommendation of the prosecutor. The court hereby convicts Mr. Thomason of the third-degree felony offense of evading arrest or detention with a vehicle, assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division, assesses a $1,500 fine. Court takes into consideration under section 1245 of the Texas Penal Code, cause numbers CR 2314 and DA 202749. Court awards Mr. Thompson 262 days credit for the time that he has spent in jail on this cause. Mr. Thomason, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you step forward to be fingerprinted. Good luck to you, sir. You may, yes, sir.
Did not include that.
Thank you, sir. Thanks, sir.
No, good.
We're gonna go ahead and see if we can't work on that. Because we're on a break and they're okay and they're here. Ms. Tabram, just let me know when you have someone ready.
They're bringing all four up right now.
Thank you, ma'am. Appreciate your help. Thank you. Are we doing a hearing on Mr. Hansard?
Judge, I think, I do believe that we have to hear this. My God, actually, sorry. I think you will be.
Judge Martin?
Yes, ma'am.
We're ready on Madison Martin and Mitch Adams.
All right, Ms. Martin, if you'll make your way up. This is cause number CR 19287, State versus Madison Michaela Martin. And I show set for motion to revoke today, but my docket's been incorrect throughout the day. Mr. Adams, are we set on a motion to revoke?
That's right, Your Honor. And we have an agreement with the state.
Okay, and what's that agreement?
Ms. Martin was originally sentenced to 7 years TDC, probated for 5 years with a $2,000 fine. That was back on January of 2020. Our agreement is for Ms. Martin to plead true to paragraphs 3 and 4 of the state's motion to revoke. It's my understanding the state intends to abandon paragraphs 1 and 2. In exchange for that, she will be sentenced to, or the recommendation will be 5 years confinement TDC with balance of financial obligations.
Do you have any back time credit?
238 days.
And did you say the original charge was evading arrest, 3rd degree,
That is correct.
motor vehicle?
That is correct.
And does your client waive the reading of the state's motion today?
Yes, Your Honor, she does.
And the state's abandoning counts 1 and 2 in their motion?
Yes, I believe that's right.
And it's a 4-count motion in total, is that correct?
That's correct.
Just one moment. Oh, sure, sure. All right, Ms. Martin, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. You may begin now. Make sure you speak up loudly and clearly for me so my court reporter who's present in the courtroom can hear and take down what you're saying, okay? All right, no problem. Ms. Martin, you appeared before this court on January 9th, and I'm having displayed for you the state's motion to revoke. You appeared before the court on January 9th of last year, 2020, and the court heard the evidence in your case and convicted you of the 3rd-degree felony offense of evading arrest or detention with a vehicle. The court assessed your punishment at 7 years confinement in the Texas Department of Criminal Justice, but the court suspended that sentence and placed you on community supervision for 5 years. It was during your period of community supervision that the state has filed in its motion to a motion to revoke your community supervision, counts 1, 2, 3, and 4. The state having abandoned counts 1 and 2 at this time, the court would ask you, Ms. Martin, how do you plead to counts 3 and 4 as provided here in the state's motion? Are those counts true or not true?
They're true.
All right. And Ms. Martin, are you pleading true to these counts because these counts are true?
Yes, Your Honor.
Has anyone threatened you or forced you or pressured you to plead true to either of these counts?
No.
All right, the court will accept the defendant's plea of true at this time. And Mr. Adams, is there any objection to the admission of the defendant's waiver of rights and plea of true as State's Exhibit A?
No objection, Your Honor.
All right, State's Exhibit A is admitted into evidence and the court takes judicial notice of Ms. Martin's judicial confession. Is there anything further from the state?
Nothing, Your Honor, we rest in peace.
From the defense?
Nothing further, we rush.
All right, then based on the evidence, the court's going to find, Ms. Martin, that you have violated the terms and conditions of your community supervision. The court this day will follow the recommendation from the state. The court revokes your community supervision, assesses your punishment at 5 years confinement in the Texas Department of Criminal Justice. Court orders you to pay the balance of your financial obligations previously imposed. The court awards you 238 days credit for the time that you have spent in jail on this cause. Ms. Martin, when you get out of TDC, it's important that you report to the Van Zandt County Courthouse so you can make arrangements to pay off the monies that you owe. Your failure to do so may result in the court issuing a warrant for your arrest. Do you understand that?
Yes, Your Honor.
All right. So Ms. Martin, this time I'm going to ask that you be seated and someone's going to come and they're going to fingerprint you. And then we wish you good luck.
Thank you.
Who's next, Mr. Abraham?
Mr. Adams is gonna talk to his other defendant. Do you have, Mr. Gamble or
Mr.
Mr. Ashmore?
Yes, both are available and ready.
Mr. Hander, Mr. Gamble.
Well, no,
Hansard.
Mr. Hansard will not be next because he's going to be, his is going to take some time. I need Mr. Ashmore's client. What's going to be?
Well, Your Honor, we have these pretrial motions that we filed in his cases. So, essentially, Your Honor, I've explained to my client multiple times that the Van Zandt County skating order covers all the things that he's requesting that we dig into and flip over all the rocks. We're pretty confident, 99% confident the state has been transparent with us on all the cases that he's currently facing, which are 4 charged, 2 unindicted as of yet, as I understand things, and I've explained to Mr. Howard. He wants a trial, as I understand it from Mr. Howard, and has rejected the offer of 40 years. And again, has no confidence or little confidence that the Van Zandt County skating order sufficiently protects all his rights regarding disclosure of witnesses, being victims advocates, criminal records, et cetera. So these are identical motions, but he is facing 25 years plus on if he's convicted of any one of these. And, we're just here out of an abundance of caution, making sure we're doing our diligence. I've confirmed with the state, they understand why we're doing what we are doing.
And what we're here today on is the motion to disclose informants, correct?
Informants and then these other, general pretrial matters, which I know we're not exactly up on a pretrial date yet, right? Because we're not going to be picking a jury next week, or likely, I know he's not in the top 10.
No, I mean, we're exactly where we need to be because we need to take up the pretrial issues before we get to trial. So what's contested at this time? The motion to disclose informants?
Judge, the state's opinion is that there are no informants involved in this case. The state's also of the opinion that even if there were, there are independent basis for the stop. So any informants, would they exist, which the state does not believe that they do exist, they would not be required to disclose the independent basis for the stop and detention of Mr. Howard. And I believe it's just the one case, correct? I believe there's only a motion to disclose informant in one case, correct?
I think we filed them, but I could be mistaken. And I know that there is also the more global omnibus pretrial motion that we used to file pre-standing order, which I know the court doesn't want us to file anymore. However, Mr. Howard has insisted, and we're trying to make sure that we're doing our due diligence on these pretrial matters to ensure that.
I understand. Let's do this. Let me do this. Motion to disclose informants. Number one, motion to disclose informants. Are there any informants from the state?
No, there are no informants.
If there are informants, the state agrees to produce them or does not agree to produce them?
If at any time that a informant becomes known to the district attorney's office, and I further inquire, again, I just thought that it was just on the possession of controlled substance, PB2, with 1 to 4 grams, which is Will's point. I have Will's point officers here. I thought there was just a motion to disclose informant on that one case. The other cases are burglary of a motor vehicle. I don't understand how there could be an informant on those cases, and a bail jumping, which obviously I don't believe there would be an informant in rational sense involved in that case. So I thought there was just one motion to disclose informers. In the PCS case, we were prepared for that. I concur with those points. They do not believe that there is an informant in this case. And the state would argue that even if there were, we would not be required under statute to disclose at this time.
So I'm a little concerned about believe, the word believe. So you've consulted with Wills Point PD and they believe that there was not, either there was an informant or there was not an informant.
Since there's not an informant.
Okay, so there's no informant. So the court's going to, and so the state's position is that there is no informant. So the court's going to grant the defendant's motion to disclose informants, and the state, you're disclosing that there are no informants.
We are comfortable with disclosing that there are no informants.
Okay, and
The defense has no, we appreciate that.
all right, so what is issue number 2?
Again, the names of the witnesses. And I know this, we have 4 cases, so.
All right, so
Bail jumping.
I believe that the court has already in its standing pretrial discovery order has already granted that. So the defendant's motion to grant witness or to disclose witness information is granted.
State has no opposition to that. The employees internal role.
And again, next one would be, and I hate to belabor this, Judge.
No, it's important that we get through this. So what's item 3
So
for
the
Mr. Howard?
Next request, even though I believe it's discovered in the standing order, is any victims advocate that the prosecution may call.
Victim advocate as a witness on behalf of the victim, or like victim impact statement evidence?
I think to be broader, it should be both, because I know there's some unindicted behavior that we understand, one of which might be a sexual assault or some sort of sexual assault in nature. So just make sure we're not dealing with anything murky. Is there going to be a victim's advocate or a victim impact that we need to know about?
Judge, I don't believe that the sexual assault case is not before this court this time, and it's not been indicted. We don't believe that there will be any victims advocate testimony. There may be a victim impact statement. We would agree to turn those over in accordance with law at the proper time in this process.
Court will grant the defendant's motion as to victim impact statement and victim advocate information in accordance with any disclosure statutes.
Thank you very much, Your Honor. The criminal records of any witnesses, especially honesty crimes, crime of moral turpitude.
I believe the court has already granted that in its standing order, so the defendant's motion is granted.
Again, the state has no.
Any competency information regarding any witness the state intends to rely on?
Any objection from the state? You're asking if any witness has been deemed incompetent at any time prior to trial? Is that what the motion says?
Yes.
But if it comes to the states,
If it comes within our knowledge and possession, we will have to turn over any mitigating or exculpatory evidence to the defendant. If it does come to our knowledge, we will absolutely inform the defendant and through his defense.
so the court will grant defendant's motion regarding disclosure of competency information regarding any witnesses that is not protected by HIPAA and is in the state's possession.
Thank you, Your Honor.
What's next, Mr. Ashman?
The request from the defense is that the state tender any inducements that might motivate witnesses to testify in favor of the state against Mr. Howard, showing any cooperation, things of that nature.
And I believe the court's already covered that in its standing order, so court will grant him a second order conferring that benefit upon him.
Thank you, Your Honor. As we covered in the former, another request is writing to you to refresh the recollection of any witnesses that may be outside of what's been already supplied by the state, which is a good amount of documents.
I believe that's adequately covered in the Texas Rules of Evidence. However, court will, and I believe that's covered also by the court standing order. So the court will grant the defendant's motion for the state to produce any writings used to recall the memory of any witnesses testifying in this court.
There's a 4-part expert witness, but I think I can just summarize that. We do know there's going to be some drug evidence, drug recognition evidence, testing evidence. So essentially what's required under 3914 and state law regarding what we anticipate is going to be a testifying expert on these drugs that are part of the cases you're on.
And I believe that's covered in the court standing order. So the court will, and by statute, state has no objection. Court grants the defendant's motion that the court's already ordered in his favor.
The next request, Your Honor, is regarding Mr. Howard's statements that he may have made in the state inadvertently or directly. So any oral admissions, statements made by him, any jail calls made by him, any warnings, admonitions given by the state or its agents to Mr. Howard before he made any such statements. Finally, the statements that the state may offer or intends to offer the evidence that he may have made to other witnesses.
I believe that's covered by the court standing order. No objection from state.
And by statute.
Court grants the defendant's request regarding disclosure of the defendant's statements.
Next request is any search warrants or subpoenas obtained by law enforcement regarding any of the searches that have not been already produced, which we believe that we've got some volumes of what's been produced. Excuse me, I'm going to rephrase that. We know specifically we have volumes of what's been produced, making sure we got them all. Or any additional subpoenas, warrants, affidavits, and some more things like that that may still be out there. Requested.
I believe that the state's required to produce those anyway, and I believe that is covered by the court's standing order. So the court will grant the defendant's motion on search warrants or subpoenas.
The next request has to do with any police reports, investigations, handwritten type notes that pertain or relate to this case that were generated by or maintained by law enforcement. Excluding that which has already been produced, which is a significant amount of data. Again, we're trying to make sure we look up through and come through everything we can for Mr. Howard.
Court grants the defendant's request in the court standing discovery order. Court will grant it again.
Okay, thank you, Judge.
Is there anything on his list that the court hasn't already authorized, just so we can save time?
I don't believe so, Your Honor. I've read that standing order pretty thoroughly. I think it's.
State, is there anything that you view in Mr. Howard's motion that you believe is not covered
Judge, the only issue that the state saw beyond is the mental health of any witness, which we don't necessarily have.
Well, we've already covered
We've
that.
covered that. Beyond that, no, we believe everything's covered by the court.
And you have no objection to the remainder? Then the court, then just for brevity of time, the court's going to go ahead and grant Mr. Howard's continued requests in there. So Mr. Ashmore, if you'll prepare an order reflecting that and provide that to the state, and the state, if you'll agree to that or sign it or not, and submit it to me, then I'll get it signed.
Thank you very much.
Is there anything,
The court has granted all, we have no objection. If Mr. Edwards would like to submit that.
is there anything that's contested today between the state and the defendant regarding these pretrial motions?
I don't believe so. We've had a chance to confer and the state understands that we're trying to make sure that we've done everything right here and very cooperative with our office.
Is Mr. Howard set for anything else?
That's it, the jury trial said. And I would request an admonition before this ship sails that with regard to rejecting all pleas, moving forward with what looks to be 4 cases, all of which can be enhanced to life sentences, and giving up any further opportunity to reach a resolution, a reasonable resolution to say that's.
So Mr. Howard has 5 pending cases before the court on the court's docket today. State, can you tell me what the offer is to Mr. Howard in each one, beginning numerically?
Judge, I believe the state's offer to Mr. Howard was 40 years on, I believe he could select the case that he would like to plead upon. We would take into consideration the remaining case. We had never made specific offers as to individual case. He said that his and Mr.
Yeah,
advice, he could pick whichever case he believed, given parole and multitude of factors he believed would be in his best interest to plead to. We would offer him 40 on that specific case, take everything else into consideration. I would also note for the record, the state intends, if we proceed to ask the court to stack any all sentences exceeds. I believe the only 2 that we would have some discussion about coming from the same transaction, of course, conduct would be the 2 burglary vehicles, 2 previous. Everything else is a separate criminal transaction, alleged criminal transaction. We would ask the court at the proper time to stack his sentences just for Mr. Howard's application, make sure he is aware that that is the state's intention.
Mr. Howard's charged with a correct me when I'm wrong, a 2nd-degree felony offense of possession of controlled substance in penalty group 2, 4 grams to 400 grams.
Yes, good.
A 2nd-degree felony robbery.
Yes, Your Honor.
I show a state jail felony burglary of a vehicle.
Yes, Your Honor.
Has that been enhanced further up in state jail?
Judge, actually, I do believe. We put that record. State jail. I'm sorry, Judge. Yes, those are both state jail felony offenses that have been enhanced by criminal history to secondary.
So there are burglary of vehicles that have been enhanced to state jail and then further enhanced to second degree.
Yes, Judge.
So maximum 20
20 years.
if the enhancement paragraphs are found to be true.
Yeah, of course, of course. Including the previous burglary enhancement, would enhance a burglary to a state jail, and then prior criminal history, we believe would enhance to a secondary.
And lastly, a bail jumping third degree felony. Are there notice of enhancements alleged in that case as well? And it elevates it to a what?
The third degree felonies, we believe, third and second degree felonies are enhanced by previous criminal conduct, 25 years in prison.
And do you agree with that, Mr. Ashman?
I believe that's correct, Your Honor.
All right, Mr. Howard, can you see and hear me okay?
Yes, sir.
Okay, all right. And have you been able to hear what the prosecutor has said and what your attorney, Mr. Ashmore, has said?
Yes.
Okay, so the court has reviewed your request on pretrial motions, and as you've heard, the court has already ordered all of the items. Let me rephrase that. Most of the items that you have requested, and the court has granted the remainder of the items to be disclosed to you. So now we're going to decide whether or not we're going to set this for a bench trial or a jury trial or a plea agreement. Okay. So at this time, Mr. Ashmore has asked me to remind you that those are your options. All right. A trial before me as the bench, where I would decide if you're guilty or not guilty, and I would decide what your sentence is if you were found guilty. Or you can request a jury trial and request a jury to determine whether you're guilty or not guilty. And if they find you guilty, then at that time you can determine whether you want the jury to assess your punishment or you want me to assess your punishment. Or your third option is to reach some kind of agreement between you and the state to resolve your case. Do you understand those three options?
Yes.
And do you understand that if we set you on a jury selection docket, that means you pick that option 2 to have your case tried before the jury, that the court may not let you enter into a plea agreement after today? Do you understand that?
Yes.
And understanding those things, how do you want to proceed?
Trial.
Trial before a jury? Jury? Okay. All right. The court will place Mr. Howard then on the jury selection docket beginning next week on Monday, April 5th. Obviously, Mr. Howard's case will not be reached for jury trial on that date. However, the court will place Mr. Howard on the court's jury selection docket each and every month until his case is in the top 10. Once your case is selected for trial or becomes in the top 10 of cases that the court may try, then Mr. Ashmore will be in court with you at that time. You understand that? Otherwise, you're not going to be brought before the court every time we're set for jury selection. We'll just send over the paperwork to you until that time that the court selects your case for trial. Once that happens, then the court will have Mr. Ashmore make an appearance with you, and then we'll pick a jury for your case, and we'll give you that jury trial. Do you understand?
Yes.
Okay. Do you have any questions for the court today, Mr. Howard?
I have one pertaining to the robbery.
Well, is it one regarding evidence or something that you need to discuss with Mr. Ashmore, or is it a procedural question about your jury trial?
So I guess it's procedural.
All right, well, let's go ahead and tell me.
I was arrested on that this year. Well, in October, the 18th, I think. But I was indicted on it in September.
So I don't see how was I already indicted on the charge I had been arrested.
Okay, I'll bring that to Mr. Ashmore's attention and are you aware of what he's speaking of, Mr. Ashmore? He's saying that he was indicted before he was arrested. Is that true? I mean, is it?
I think that there was a period of time when he was out, he got a bond. There were additional offenses. There was a failure to appear and he was rearrested. I don't know that specific sequence, and it's off the top of my head. He got about a 5+ page letter from our office in the last couple of days outlining all of that. And Mr. Howard, I'll be happy to come by or call you and we'll talk about it all again.
And it appears to me, Mr. Howard, that you were arrested on what is known as an after indictment warrant, meaning that you were not arrested at the time of the offense, rather the case was presented to the grand jury and a warrant was issued for you at that time. So Mr. Ashmore will discuss that with you in more detail, but that's my understanding, is that you were arrested after indictment.
But the arrest was an assault.
Well,
It started out as an assault.
let Mr. Ashmore come out. Let Mr. Ashmore come out and discuss this with you, so you can have that discussion in your attorney-client privilege. And then he can explain that to you. And if you're not happy with that explanation, then the next time we see each other, then I'll help clarify for you. Okay? All right. Thank you, Mr. Howard. All right, so that just leaves Mr. Hansard, correct?
Mr. Richardson with Ms. Chad.
So I can't hear you. Say that again.
Chris Richardson with Mitch Adams.
All right, and Mr. Adams, what's your anticipated announcement on that?
Your Honor, we have we've reached an agreement with the state to resolve Mr. Richardson's cases. The proposed solution was conveyed to me by Mr. Woodwhite yesterday. I had a minute here to discuss it with Mr. Richardson, and he's indicated it's a proposal, a plea offer that he's willing to take because of the lateness of these things happening relative to today's hearing. We don't have the plea papers prepared and ready to go. If the court is interested in taking it up this afternoon, assuming we can put all that good pressure on the DA's office to turn that plea paper out then, or we could reset it for a plea hearing at some point in the future.
I would like to get it done today if we can.
Judge, the only reason I would suggest that we not is that there's a new case that has not been filed. We actually received it in our office on Friday. I made Mr. Adams aware of the new case yesterday. So I would need the time to file it and then have Ms. Ebony do it. We could try to get it done today, or if it would be easier to reset it for a couple of days. It's a plea for some short period of time in state jail at the court's convenience.
Are you
Your Honor,
available on Thursday, Mr. Adams?
yes, I think so. Let me double check so I'll speak out of time. I am available, Your Honor. I have a 3 o'clock hearing, but it's going to be by Zoom, so I can be anywhere.
Okay, let's just Mr. Richardson then to enter a plea on Thursday. And that'd be at 1:30.
Very good.
So Mr. Gimbel, it looks like you and Mr. Hansard will need to appear back at 1:30. I don't think we're going to get to that in the next 15 minutes. So I'll need to take up Mr. Hankins and with Mr. Head. So we'll just have Mr. Hansard back at 1:30. Ms. Abraham, if you can let jail staff know.
Yes, Your Honor.
How do you want it? Then I'd have Mr. Hansard appear via Zoom and you can appear in person, or you can appear at the jail with Mr. Hansard.
I will visit with Mr. Hansard over lunch and
Okay.
verify.
It's easier on the jail staff to not have to bring them over. So that's why I say defendant there. But if you want them here, let me know and we can try to make that arrangement. I know they're shorthanded today.
That sounds good.
Okay. And if you want to head that way now, you might be able to catch them before they put them back. Deputy McLeish,
Yes, sir.
can Mr. Hansard stay there in that room? Mr. Gimbel, I believe, is on his way. He'd like to discuss with him.
We'll put him in visitation. How about that?
Thank you. Appreciate it.
Okay.
Thank you, Aaron.
All right, we are back on the record and CR 2121, State versus Quincy Lamar Hankins. Update for the court.
Sorry, we have reviewed the video, we reviewed it together, and I think we're ready to proceed at this point.
And we've got about 10 minutes till lunch. So we can go ahead and begin and work for 10 minutes, or we can just take a recess and begin promptly at 1:30.
With the court permission, I thought we wanted to proceed now. I think it's much easier.
Okay. Trooper Fagley. All right, Trooper, you recall that you're still under oath.
Yes, sir.
Just have a seat. All right, go ahead, Mr. Head.
There is a body cam video, correct?
Yes, sir.
And you have now provided that to the state, and that was just due to some sort of error as far as downloading or something of that effect.
Yes, sir. Yeah.
And have you had an opportunity to watch that video?
Briefly.
Would you agree with me that in the video, when y'all discussed the search, that Trooper Rhodes indicates to you to search for an open container, and then he kind of whispers quietly, and for any drug containers? You recall that on the video?
I recall the open container. I don't recall what was whispered.
But it's your recollection or your understanding you were to search for contraband, being open containers or any other illegal items.
That were located during the probable cause search, yes, sir.
And in fact, when you went to the vehicle, you went to the front passenger door first in order to unlock the doors. Do you recall that?
Yes, sir.
You looked inside with a flashlight.
Mhm.
Prior to that time, you had already seen a bottle in the back seat, hadn't you?
Yes, sir.
So you unlocked the doors, then opened the back passenger door.
Yes,
correct?
sir.
At which time you retrieved the open bottle of Crown Royal.
Yes, sir.
And that was the container that Mr. Hankins had indicated Trooper Rhodes was in the vehicle.
That was the only one he admitted to. Yes, sir.
And do you recall after that then you began searching through some bags in the floorboard?
Yes, sir.
There was a white plastic bag, there was a black plastic bag. Neither one of those contained anything that appeared to be an open container, but you searched through those, didn't you?
Yes, sir.
In fact, some of them had some medications. You even read the labels on the medications.
Yes, sir.
Put one of the medications on top of the car, beside the Crown Royal bottle.
Yes, sir.
And as you were doing that, do you recall speaking into your body mics, reading the label, saying, you know, some of these medications?
Alcohol may intensify the effects.
And you do that when you know things so that it is preserved on your body cam, correct?
Yes, sir.
And that way it's there to refresh your recollection as well as for the prosecutor and the defense later on to know what you saw at that time.
Normally to refresh my, yes, sir.
Now, after you did that, you agree with me, you went back to the front seat.
Yes, sir.
And you looked around in the console area where the cup holders were.
Yes.
At that time, you noted there was a cup with the same type of alcohol you believe is what was in the Crown Royal bottle.
Yes, sir.
You made a verbal notation of that on your body cam.
Yes.
You also looked all around that console area. Would you agree with me? You did not say anything about any sort of marijuana residue.
I believe I did state about green residue. Yes, sir.
You believe that's on the video?
I believe so. Yes, sir.
Hey, have you, but you've not had a chance to carefully watch the video today?
No, sir, not today, no.
Okay. Well, and if we take a break over lunch hour, could you make a point to watch that video to refresh your recollection?
Sure.
All right, now, moving on, do you recall specifically seeing a cigar on the center console?
No.
You don't recall picking up a cigar,
No.
looking at the end of it,
No.
bringing it up, smelling it,
No.
and then setting it back down on the console?
No.
Now, had there been anything unusual about that cigar, is it fair to say you would have, number one, seized the cigar if you thought it had anything illegal in it?
Yes, sir.
And number two, noted it on the video?
Not always, no.
But to be clear, you did not seize a cigar in this case?
No.
Okay. Likewise, residue from marijuana is not illegal, is it?
What's your definition? Residue. My definition, yes, is illegal is possession.
Okay. Well, isn't the law on marijuana that you have to possess a usable quantity of marijuana for marijuana to be illegal? Is residue, in your opinion, usable?
It can be, yes.
Did you attempt to collect any of this so-called residue that you saw on the console if you felt like it was potentially an illegal substance?
No.
And you didn't photograph it?
No.
And after you did that, did you then lift the lid to the center console between the front two seats?
Yes, sir.
Now, you would agree with me that nothing inside that center console was visible to you until you lifted that lid. Is that fair to say?
Yes, sir.
And likewise, when you lifted the lid, is it fair to say there was a tray that sits there on top of that console? Once you lift it?
A portion of that console, not the entirety of it.
Right. And there was nothing that you felt like was illegal or anything in that, in the tray?
What I could immediately see, no.
Right. And there were certainly no open containers of alcohol in the console, correct?
After my complete search for the console,
Well, did you see anything that appeared to be an open container when you opened the lid?
no, but there were several items in there that would be obstructing my vision for that.
And fair to say you did not observe anything that appeared to be illegal once you initially opened the lid?
Not at first sight, no, sir.
You had to actually manipulate some things, move some papers around, look under what appeared to be maybe a lottery ticket or something before you observed something that you felt like was an illegal substance.
Yes.
And at that time, do you recall that what you felt like it was possibly ecstasy?
One of the items in the package, yes, sir.
So you recall that you did not make any mention of marijuana at that point in time. You made mention of ecstasy, no mention of marijuana.
Correct.
And it was only at a later point that you actually made a notation on the video and actually had, oh shoot, there's also something in there that looks like marijuana at a later point.
Correct.
Now, you're familiar with what an arrest PC affidavit is, aren't you?
Probable cause affidavit, yes, sir.
Yes, sir. And fair to say that those are made under oath.
Yes, sir.
They are required by law to be truthful and accurate.
Yes, sir.
Have you reviewed the PC affidavits in this case?
No.
But you're familiar generally with what a PC affidavit is?
Yes, sir.
Now approach with insurance.
You may.
Trooper, I'm showing you what appears to be a copy of a probable cause affidavit. Can you take just a minute to just briefly look over that?
Yes, sir.
Would you agree with me that this affidavit appears to be from the day in question regarding Quincy Hankins?
Yes, sir.
And it appears to bear Trooper Rhodes' signature.
Yes, sir.
And he would have done the affidavit in this case, correct?
Yes, sir.
Would you agree with me that under oath, Trooper Rhodes specifically said,
Your Honor, I'm gonna object. This is, this piece of evidence has not been admitted. I would object to any specific offerings, specifically since this is not proper sponsoring with this.
I'll sustain the objection.
going back to your supplemental report, would you agree with me that in your supplemental report, you do not list any potential clues or indicators of intoxication exhibited by Mr. Hankins on that time that he was detained?
Correct.
And certainly being a DPS trooper, you're trained in DWI intervention.
Intervention,
Well, stop.
investigation.
Investigation. And so you're familiar with the manual, the training and everything related to clues of intoxication.
Yes, sir.
And you agree with me, you did not put any of those in the report to indicate that you observed any clues of intoxication.
Yes, sir.
But during the time that you were conducting the search, is it true that Mr. Hankins was being detained for a DWI investigation?
During his standardized post-strike test, yes, sir.
And in fact, he was successful on those tests, or no clues of intoxication were noted on those standardized field sobriety tests. Is that true?
I have no idea. I did not conduct or observe those tests to my recollection.
Do you recall statements by Trooper Rhodes to you that he was fine, he was not intoxicated?
I do not recall any statements that the trooper wrote.
I'll pass it.
All right, the court's going to stand in recess on this case. We'll resume promptly at 1:30. Trooper Fagley, you are still under oath and you are still under the rule.
Yes, sir.
All right, you may step down. Mr. Ashmore, if you'll get your client, Ms. Murray.
Yes, sir.
What you got? All right, Ms. Murray, if you'll raise your right hand, I'm going to place you under oath. Ms. Murray, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. You are Susan Ann Murray, correct? Ms. Murray, you've been indicted in cause number CR 1924 with the felony offense of misapplication by a fiduciary of financial property between 30,000 less than 150,000. You're also represented in this case by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your case with him and have all of your legal questions answered? Is there anything about this pretrial intervention contract that you're asking the court to approve today that you do not understand? It's my understanding that in this contract, Ms. Murray would be subject to 1 year of supervision in addition to all of the standard conditions, that restitution would be in the amount of $7,500 payable today. Is that correct? And has that already been paid?
No, I haven't passed, but I have to do next one, so that will be paid as soon as we're done.
And is that the entirety of the restitution that's being collected?
Yes, sir.
And has that been agreed by the victim? Because I saw it's been 50, it was 15 to 30, or I'm sorry, it's 30 to 150.
Yes, Your Honor, that's the way it was originally filed with our office. The provable amount turned out to be less.
Okay, and so the victim's aware of that?
Yeah.
All right, Ms. Murray, do you understand if the court approves this contract today that you would be waiving a few very important rights? One would be the right to have your case tried by a jury of your peers. You also understand that you would also be giving up any claims for a speedy trial, and you'd also be giving up your right to have your records expunged with respect to the DA's office and the probation department. Do you understand those things?
Yeah.
You've discussed all those things with your attorney, Mr. Ashmore, and you've made these decisions intelligently, knowingly, and voluntarily of your own free will. Is that right? Mr. Ashmore, you and the state have joined in with Ms. Murray asking for a waiver of jury trial. Is that correct?
That's correct, Your Honor.
And you've also counseled your client on the waiver of speedy trial and her limited waiver of expunction.
Yes, Your Honor.
All right, the court's going to find that Ms. Murray has entered into her waivers intentionally, knowingly, and voluntarily. The court will approve the waiver of jury trial and the waiver of speedy trial and limited waiver of expunction in open court. So, Ms. Murray, you understand that by being placed in this program, that if you are unsuccessful in completing your requirements and conditions, that the case can be restored back onto my docket. And if it is, the court could proceed right to trial in this matter before the bench. You would not get a right to have a jury decide the issues here on whether you're guilty or not guilty, or issues of restitution. You would be brought back to court, and I could immediately set you for trial. And if the court found you to be in violation of your pretrial intervention contract, the court could then also find you to be guilty of this offense. And I believe that this is indicted as, what is the level of offense? Is this a third degree?
My recollection is.
It may be, is it third degree or is it higher? It's misapplication by fiduciary, 30 to 150. I don't have a judgment. I don't have it on my docket, so. But is that enhanced by the misapplication by fiduciary? Usually fiduciary bumps up one, I believe.
It's indicted as a third-degree felony. Third, 3103 theft, third-degree felony.
This is why 30,000, 150,000 is third degree. It's section 3245, misapplication of fiduciary property. Value ladder is 30,000, 150,000, which is a third degree.
Okay, but I think it's just indicted straight third degree. I don't see any misapplication. I don't see any fiduciary elements alleged here. It's just by acquiring or exercising control over currency 30 to 150 from the owner. So it's not, it's just theft.
Same value.
Okay, but here where it says misapplication, that would be incorrect. It would just be theft, or is that? Does she have more than one charge or just one charge? So do we need to, here, let's come change the front page of this so that it is supported by the evidence.
Yes, sir.
You may. All right, so Ms. Murray, if the court finds that you violate at a later date the conditions of your pretrial intervention contract, the court could bring you back for a trial before the court on the charge of theft of property, a third-degree felony offense, which would carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice Institutional Division. And by entering into this contract, you're stipulating to the evidence from the state. So the court would be able to review that evidence and proceed to trial based on that evidence alone. Do you understand that? You're asking the court to approve the contract today? All right, the court approves the contract, finds that it's been entered into intentionally, knowingly, and voluntarily with the advice and consent of counsel. Court orders Ms. Murray into the program for a period of 1 year, orders $7,500 to be submitted and paid today to the Van Zandt County Community Supervision and Corrections Department. Court has this day signed the pretrial intervention contract approving the same. So Ms. Murray, I'm gonna order you to visit with Ms. Burns here. She'll give you additional information. All right, we'll stand in recess till 1:30. Yes, thank you, Ms. Usher.